Item number 7. So affidavit has been filed. So I shall have to file reply. So 4 weeks time may be granted.
Item number 7.
7. Yes.
Who has filed affidavit?
Government.
Government.
Fine. Respondent number 5.
On the prayer of Sri R.M. Chaudhary, learned counsel for the petitioner. Matter is adjourned by 3 weeks to enable filing of rejoinder affidavit.
Masuk.
It is a lot. Lordship, I back to item number 16.
1-6.
One.
Yes.
It will be taken up after 2 weeks, my lord.
On a prayer made on behalf of the petitioner. I have taken the consent of APDCL.
No, my lord.
Take the consent, they are there available. Why didn't you make a call?
My lord, probably the new standing counsel has been deferred. My lord, I'll get his number and inform him.
Inform him first, then you will adjourn, but not now. Take his consent, inform the court. Adjourn hobo kintu herita. Pisot adjourn kori. Pori choi dia.
Back to mention item number 4.
40?
Item number 4.
4. Yes.
My senior is out of session. So back to
Who is your senior?
M.H. Ahmed.
Okay. On a prayer made, Revenue Department, madam. On a prayer made on behalf of the petitioners, matter is adjourned by 2 weeks. 2 weeks.
Lordship, another mention plan matter WPCC 1990/2023. The land matter, this matter is urgency. So back to
What is the stage now? Stage of the matter?
admission. Admission.
Admission. It was last listed when?
Last 3/4/2023.
3/4/2023 or 24?
At the last posting was 6/4/2023.
Okay. Okay. When do you want?
Matter
When do you want?
2 weeks later.
2 weeks. We'll have it listed. Okay. Give a date after a week. Yes.
Please, Your Lordship. I pray for listing of the admission matter, my lord. It was listed several times, but it was left out because of shortage of time, my lord. Matter is an
Bench
urgent
5 matter.
bench 5 matter.
Okay. Matter which year?
Matter of 2023. The issue is that, my lord, we have challenged the reinstatement of the chairman of the board of directors, my lord, although he was terminated for corruption, my lord. Several occasions it was listed, and the thing is that, my lord, the term of the board is going to be expired on 23rd of June, my lord.
Okay.
Next week, any that, my lord.
Okay.
And your blessing.
Bench 5 matter.
Yes.
May Lordship. Lordship, already order is completed by the respondent authority.
Okay. Your Islam.
Yes, Lord.
Sri Islam, learned counsel for the petitioner has submitted on instructions that the order dated so-and-so, passed in WPC so-and-so has been complied with. Full stop. As complied, and therefore he wants to withdraw this petition. Full stop. Para. In view of the aforesaid submissions, comma, that this petition is dismissed on withdrawal.
Okay.
Written petition contempt. Okay.
Item 1.
Content application matter. Today is the first date matter notice may be.
Where is the order?
Case 10 matter. Now party Lordship and case 13.
there is a direction for disposal of the representation within a period of 4 months, within an outer period of 4 months. Now it is almost for 1 year. Correct. Sir. Now the direction was passed on 24th of 7.
There is a recent communication of February 2024.
My lord, initially, my lord, what happened? The Deputy Commissioner and the Circle Officer, my lord, only the commission are taking place between these two officers, but ultimately nothing is happening.
No, the last communication. That is a which date?
This,
This-
my lord, 20th of February.
2020?
20 to 20 days 70.
Date.
It is 20th of February 20
20?
February
20th of February, which year?
24.
24. So it's not, it's a recent document.
My lord, actually this letter was, but ultimately, my lord, they are even when I this letter was sent to the circle officer, but when I approached the circle officer, my lord, but actually they informed that the direction was issued to the deputy commissioner to dispose of the my lord, dispose of the matter. So ultimately, when the circle officers had also, my lord, not responding. And secondly, my lord, earlier also from the circle officer side, one letter was sent to the deputy commissioner that page 16, my lord, that only they are concerned that they actually they do not since they were not directed by this portal.
You are MA Islam,
MA.
part 3 MA Islam.
Let
Huh?
notice be issued, man. In the meantime, if they comply with the order, ultimately, I could say.
Complained regarding non-compliance of the order dated so-and-so past in so-and-so. It is further submitted, though certain communications have been exchanged, comma, the directions which were to be complied with within a particular time frame has not been done. For stop para. Let notice be issued. No? Steps registered post by Monday. 4 weeks.
All right.
Item 2. Non appears for the petitioner on call. Full stop. The subject matter of this contempt petition is an order dated 24/5/2023 passed by this court in criminal revision CRL REVP 203 of 2023. Full stop. A perusal of the said order annexed to this petition would show that while issuing notice, this court had directed that till the returnable date, further proceedings in connection with criminal case number 25/2003 arising out of DV case number 29M/2003 pending in the court of the learned additional session judge number 5, Kamrup, within bracket M, Guwahati, shall remain stayed. Full stop. The allegation which has been termed as contempt is with regard to non-payment of maintenance. Full stop. Whether such allegations may be construed as non-violation of the aforesaid order is itself an issue. Itself an issue which is to be gone into. Full stop. Prima facie, the same does not appear to be within the ambit of a petition alleging contempt. Full stop. Para, be that as it may. And in the interest of justice, no orders are passed in absence of the learned counsel for the petitioner. And accordingly, the matter is adjourned to be listed on Wednesday next. None appears for the petitioner on call, whereas Sri N. Goswami Learned State Council is present. Full stop. In the interest of justice, matter is adjourned to be listed on 24th. Yes.
My lord, this is a case actually, my lord. It has come against the order of recovery officer and I have exhausted all the remedies that there. So now I have filed this petition under 226 as a conduct as a court of equity, and I am at the mercy of this court. So Lordship, consider this case. This case will because he has taken a loan. The petitioner has taken a loan, and they have defaulted. And after, because of certain reasons, because of cardiac arrest and things, and housing loan, they have taken a loan of 28 lakhs. Out of 28 lakhs, they have paid till date 18 lakhs. But if we calculate the interest part, 38 lakhs, if you come 10 lakhs interest, so 19 lakhs is the balance. So we have given representation also on different times we have paid the different amount. I have annexed all those annexes which are paid. But ultimately, my lord, the recovery officer has given us the eviction notice. And that eviction, against that eviction notice also, subsequently the eviction notice was passed on, but I filed a petition before the recovery officer that to withdraw the eviction notice and allow me to pay the amount. And he's given me certain time. Just in short, I'm telling. He's given me certain time. But we have paid, but not up to the full extent. That's why, my lord, if you go to the impugn order, my lord, this the impugn order is page 84. Page 84. That is order recovery officer.
84.
84.
Yes.
Now, nodal officers appear for certificate holder bank for brevity. Lanark Council appear for certificate debtor for brevity. Lanark Council City paid for more time to deposit the remaining amount of loan. Lanark Council City states the city is agreed to pay all the dues, including interest and cost within a very short period, and city has already paid 4 lakh on 10/17/24. Record shows that after eviction of order dated so and so has filed a petition which has submitted the entire loan will with interest and cost will be paid up to 10/11/23. Considering the petition filed by CD, Land Recovery Officer passed an order dated so and so, which is directed to certificate holder bank to hand over the keys of evicted flat to CD number 1. But CD has not paid the entire amount till 10/11/23. Again, CD filed a petition, also filed an affidavit 9/1/24, which has promised to pay the entire loan amount with interest and cost up to 31/3/24. Considering CD's petition, an affidavit, the
Who is
land
this petitioner?
under the petition Navajyoti Kolita.
Where is the property?
Property is in Guwahati Club.
Hmm?
Guwahati Club. Is the annexer.
Just a minute, please.
Stately is there.
Oh,
Page 28.
Pidichalia Road. Okay, we'll not take this up. Let it be before somebody else. On Monday or Wednesday. We have difficulty. Please before any other bench without me.
Let him come on Friday next week.
As you wish. We'll not
Let-
pass any orders.
Next week, the date.
No, the date registry will give. Petitioner may approve the registry for an appropriate date.
Public.
Item 6.
Should we record your presence, Mr. Ganguly? Are the presence of the Learned Council required to be recorded? Are the presence of the Learned Council required to be ordered in? Huh?
Certificate record, because I think my learned friend can mention before the other.
No, no. On your names, should we record?
Yes.
Record the names.
I'm for 1, 2 and 3.
Just the name, Sri S. Mitra, Learned Council for the petitioner. Not heard, Sri S. Mitra, Learned Council for the petitioner. As well as, I heard you for, A. Ganguly has appeared for the bank. However, considering the subject matter, this court recuses from the same. Accordingly, it is before any other bench without me. Yes.
Application for vacating has been filed. Here, my lord, the government affidavit would be necessary for deciding the matter.
Come up for the first time.
Now, yes, first time,
Mr. Nath, you have filed this?
Yeah.
And you are the writ petitioner, Mr. Das?
I'm the.
Would you like to file any objections or can we go ahead?
I'll pray, my lord, if the government files an affidavit, this matter can be sorted out. Because, my lord,
No, that is on the realm of the writ petition. In this IA for vacating,
I'll have to take instructions.
okay,
because
you take instructions for listed for the first time.
Yes.
And in the meantime, government,
Lordship, I am appearing on behalf of Health Department, Mr. D.P. Bora, Lordship.
okay.
Lordship, we will file our affidavit during the course of today, Lordship.
It has been suggested in the bar that the government affidavit may resolve the entire issue. So if you file it instead of going into the IA, we
Yes.
can resolve the issue.
Because two officials of the government, my lord, nominated petitioner and the respondent number 6 as member of the pharmacy council. So
A member
two of-
as a member of
member
the
of the pharmacy council,
pharmacy, who cannot be there? Either you or him.
either he.
Okay,
So and both are official communication.
okay.
And we have shown in
Okay, okay. Hertz Free DM Nath Learned Council for the applicant respond number 6, who has filed this application for modification / vacation of the interim order dated so and so, passed in the connected WPC so and so, 5/2/76/2023. Full stop para. Sri B.D. Das, Learned Senior Counsel for the opposite party / writ petitioner, however, submits that the issue can be resolved if the stand of the health department is placed on record.
Yes.
Full stop. He
Health-
otherwise,
the two wings are there. my
he
lord.
otherwise prays for
Respondent
some
number
time.
2 and
Okay, they'll take, he otherwise
Right.
prays for some time to obtain instructions. Full stop para. considering the above, comma, list this case on,
After 2 weeks,
Mr. Nath, 2 weeks? We'll fix a date. Today is 28th. We'll have it on 6th of May. Is it okay? 6th May.
All right, sir.
Yes, what is your name?
You post on behalf of DP. Board.
U Ghosh.
Yes.
Sri U Ghosh Learned Council appearing on instruction of Sri DP Bora, Learned Standing Council Health Department, may obtain necessary instructions in this regard.
they're filing.
Are you filing? sir?
Yes, Lord. Today.
Okay. Oh, no. Sri U Ghosh Learned Standing Council Health Department has submitted that the affidavit in the writ petition is being filed. No, would be filed shortly.
Okay.
Yes, Madam Agarwal, what
May
is this?
please, Lordship.
Hmm.
Lordship, this matter pertains to the petitioner had booked a plot of land under the Jorhat Development Authority in the year 2002. It was under a scheme. Thereafter, the property was not allotted despite giving the deposit of rupees 35,000. Then the second scheme came, and in the second scheme, he registered himself and paid 35,000. But the plot of land has also not been handed over to him, and the amount of money has also not been refunded to him despite several
Second
representations.
scheme came when?
On 16/5/2002.
No, that was the first scheme.
Lordship, the second scheme is 2002.
That first scheme, when was the first scheme? You
Allotted.
said first scheme he has deposited, not allotted. You said 2002.
Copy of scheme number 2, annexure 1, advertisement is 17/4/2002.
That was the first scheme.
With regard to floating of scheme number 2, para 4, my lord.
Now, what is the first, when was the first scheme? You said first scheme he had applied, not given, then again he had applied.
Sorry, my lord, I have missed out. Already in
What
the
are the
first
facts?
scheme,
Tell us
he
the
did not.
facts, tell us the facts, correct?
Yes, my lord, under scheme number 2, he applied,
Not the
He-
scheme number 1.
my lord. In scheme number 2, he applied and he requested the interested person.
So we are not really bothered with which is the scheme, first or second. You had applied under the scheme.
Yes, my
It
lord.
might have been the second or first scheme.
Yes, my lord.
In
We applied under
2002,
the scheme. in
2002, you deposited 35K.
35,000, my lord.
It was thereafter the land has not been given to you.
The land has also not been given, and despite several representations and legal notice, the amount has also not been refunded. So our only prayer in this writ petition is that the amount of 35,000 may be refunded to us along with interest. The notice issued by this honorable court has been duly served upon the respondent authorities, but they have chosen not to enter appearance. In fact, when this matter was listed on 14/8/2023, this honorable court had directed Ms. S. Barua, government advocate, to seek instructions from JDA, Jorhat Development Authority. My lord, no instructions are there and nobody has entered appearance as well.
Yes, how do you explain your delay of 2002 to 2022?
Yes, my lord. On the delay.
And why not a civil suit? Civil suit is barred. How do you come
My
for
lord, this is
226?
against the state authority.
So
the
you
state
can't
authority-
file a civil suit against a state authority.
My lord, we definitely can, but writ jurisdiction is also maintainable.
How do you explain the delay of 20 years?
Yes, my lord. The delay, my lord, 2022, he applied, and then he, respondent number 1 issued another advertisement on 20th May 2002. Thereafter, the representation was submitted by the petitioner
When?
on 20th of January 2006.
Yes,
Again in 2009, another representation was submitted
yes,
on 30th 2009.
yes.
Then on 31st, the representation was received by the respondent number 2.
Yes,
Then again in 2011, a representation was submitted,
okay,
but that also in vain.
okay.
Ultimately, my lord, after the petitioner retired from service from Jorhat and he came back to Guwahati, he waited for a long period of time and he was suffering
Where
from
will
ill health.
dismiss this?
We
Dismiss.
we sent a legal
Fit
notice
case,
as well,
fit
my
case for imposition of cost also. You
My
cannot
lord, will
slip over your rights, madam.
My lord,
Court of equity?
constant reminders were being sent to the
Will
respondent
representation
authorities.
extend the limitation? Is that the law?
My lord, it does not, but
Then
constantly we have been approaching them.
where is your conduct? 20 years you are sleeping over your rights. How do you explain the laches? 2002 you deposit 35. Now you have come for a specific performance for recovery. What is this? Is it the suit?
Sir, it is not a suit, my
You
lord.
cannot bypass civil remedy and come to the writ court saying that it's a court of equity. Limitation will not apply.
My lord, there is one judgment which was passed by this honorable court and the
Sorry.
bank was directed to refund the amount.
Sorry.
So
Heard.
if I may be permitted to place that judgment on the.
Sorry,
record.
sorry. No question. We are not entertaining this kind of writ petition and flooding the court. Heard. MS P. Agarwal, learned counsel for the petitioner. Also heard. Sri S. Barwa.
State is not the party.
Okay.
State is
Okay.
not.
State is not a party.
State
Allah
of the-
sake.
By mistake,
stop.
this-
The petitioner has implemented only the Jorhat Development Authority and its chairman as party. And the state is not a party. Full stop. Para, be that as it may, comma. The facts projected is that pursuant to an advertisement dated 17/4/2002 by the Jorhat Development Authority, comma, the petitioner had applied for a plot of land and had also deposited and also claims to have deposited an amount of rupees 35,000. Full stop. However, the land was not allotted and neither the amount has been refunded. Full stop. It is the case of the petitioner that immediately thereafter on 25/2002, comma, another advertisement was issued by the Jorhat Municipal Development Authority. Full stop. It is also contended that the petitioner that the authority had issued receipt against the amount deposited. Full stop. Para. The petitioner claims to have submitted representations in the year 2006, 2009 and 2011, followed by a legal notice on 13/5/2021. Full stop. Para. Ms. Agarwal, the learned counsel for the petitioner, has submitted that the respondent number 1 authority, being a state within the meaning of Article 12 of the Constitution of India, comma, appropriate directions be issued for refund of the money with interest. Full stop. Para. What, however, intrigues this court is the inordinate and unexplained delay of more than 20 years, full stop, of about 20 years till the date of filing of this petition, full stop. In fact, this court in its order dated 24/7/2023 had noticed the said delay, and the petitioner and the learned counsel for the petitioner was given an opportunity to explain the same. Full stop. Para. As indicated above, comma, the learned counsel for the petitioner has submitted that representations were filed from time to time, more specifically in 2006, 2009, 2011, followed by our legal notice on so-and-so date to Para.
13/5/21.
Full stop. Para. It is a settled law that submission of representation would not extend the period of limitation. Full stop. Though the Limitation Act per se may not be held to be applicable in a writ proceedings, comma, the issue of laches would definitely be applicable. And when a suit before the civil court is barred by limitation in a matter of this nature, wherein the time prescribed is 3 years, comma, in absence of any plausible explanation, comma, this court, being a court of equity, cannot exercise the said jurisdiction, full stop. The constitutional bench of the Honorable Supreme Court in the case of State of Madhya Pradesh versus Bhailal Bhai, reported in 1962, AR 1962, Supreme Court 1004, has laid down as follows, paragraph 17 and 21 side of para. The claim made in this petition after about 20 years cannot be entertained, and accordingly, the writ petition is dismissed.
Black.
Yes.
1913.
Lordship, here I pray for some time to file affidavit.
No, take it.
Okay.
Take it.
Sri B. Chaudhary, Learned Standing Council, Finance and Taxation Department, prays for some more time to file the affidavit in opposition. Full stop. But 22 matters, Mr. Chaudhary, file it soon.
Yes.
The matters being of the year 2022, comma, a final opportunity is granted. Full stop. However, granted by allowing the respondents to file the affidavit within a period of, within a further period of 4 weeks from today. Is there any interim order? Para interim order passed earlier, then extended till the next date of listing. We'll fix a date. There is an interim order,
Yes, ma'am.
list on, but ensure that it's filed.
Yes, ma'am.
List on 1, 2, 3, 4, on 13th of May. Okay?
Oblige, ma'am.
14, I did 14.
Yes.
I'm paying from referral number 5 and 6.
5 and 6. Who is for the petitioner? J.H. Borbuya? Not there. Is he there? None appears for the petitioner on call. Whereas Sri Asbar Learned State Council. And your name?
SS Islam.
And Sri SS Islam Learned Council for respondent numbers 5 and 6 are present. Full stop para. In the interest of justice, list after 2 weeks. Have you filed your affidavit?
We have filed the affidavit.
Why don't you file the affidavit? In the meantime, are you going to file or not? In the meantime, the respondent numbers 5 and 6 may file their affidavit. Is there an interim order?
No.
15.
I think 15, my lord, I am appearing for the petitioner, my lord. And I was taking 4 weeks time, my lord, to file the rejoinder, my lord. We have been served with the opposition by the state respondents, my lord.
Okay, Mr. Chaudhary, you are appearing?
Yes.
Okay. Matter of which year? 2022. When did you file the affidavit?
There were 6 extensions taken by the state respondent on the last occasion.
No,
my
they
lord,
had filed in October, Mr. Council, to
Well,
October, and we are in.
my lord, we
April.
have prepared and reply, my lord, it could not be affirmed, my lord, only
This
on
is not
extension.
fair. Petition is yours. The expediency, the urgency should be on your side. You don't need 6 months to file a reply. Mr.
Well-
Kandelia, what's happening?
There is some miscommunication that had happened, my lord.
Okay,
Earlier
what is your
between
name?
Vishwanath Chatterjee.
Sri B. Chatterjee, Learned Counsel for the petitioner has submitted that a rejoinder affidavit would be filed to the affidavit in opposition of the respondent number 2, full stop, full stop. He accordingly pays for and is granted 3 weeks further time to file the same.
The interim order, my lord,
The interim order stands extended till the next date of listing. You're an obsession counsel.
Yeah.
We'll fix a date.
Indulgence, I
There's
am
a-
extremely obliged, my lord.
There is an interim order, so we don't want to extend it indefinitely. A list on. Yes, Mr. Chaudhary. We grant 3 weeks time, so we fix a date after 3 weeks. 1, 2, 3. We'll have it on not 17th. We'll have it on 10th.
Yes.
10th of May. Is it okay?
Well,
Okay.
But may it be in the ensuing week, my lord, after 10th,
You tell 13th of May?
very well. Very well. As your lordship. I'm extremely obliged.
Wait, this is the last.
Yes.
Plan-
APDCL.
APDCL.
Yeah, for APDCL, he has some difficulty.
Yes, ma'am.
We'll have it after 2 weeks.
2 weeks. And my lord, my learned friend has told me that they have received instructions in this matter.
You can file the affidavit.
Yes,
Okay. How it's free. So we'll not record your submission for adjournment. We'll
Yes.
say he'll file the affidavit.
My,
How it's free, M.A. Chaudhary, learned counsel for the petitioner. Para, your name? Sri W. Ahmed, learned counsel appearing for the APDCL. Praise for, submits that he would file the affidavit in opposition for which, opposition, full stop. He accordingly prays for and is granted 3 weeks time to file the same.
DPO.
Is there an interim order? No.
No, madam. There is no.
Item 17.
Ms. Sharma, what is this?
This matter, they have entered into a one settlement with us. That is
He's not there. We'll have it in his presence. Okay.
Yes,
None appears for the petitioner on call, whereas the respondent bank is represented by Sri M. Sharma. Full stop. Have you filed your affidavit?
yes, your lord. It has
M.
been-
Sharma, who also informs this court that the affidavit in opposition has been filed. Full stop. Para. In the interest of justice, matter is adjourned to be listed after a week.
Right.
Is there any interim order? No.
No, your lord, it's a simple payment.
Okay, next.
18.
This matters, many other cases also similar.
Yes.
nature. Company
Should we take this matter?
lots.
None appears for the petitioner on call. Full stop. Sri H. Chandran, London State Council, has however informed that there are a number of analogous matters. The lead case being WPC
5402 lordship,
of
2020
2020.
Lordship.
In this principal bench,
Lordship.
5402 of 2020. Full stop. Para, in the interest of justice, list this case along with WPC so-and-so.
Much obliged.
Yes,
Well, I have got substitution of legally years, my lord. My petition is expired on my lord 24th January, my lord. Just as my lord, his wife and children filed.
what is the cause of action?
Well, main matter is a petition filed for direction of demarcation.
Demarcation.
Demarcation,
Okay, you are the legal heirs.
legally.
You are for whom?
For respondent 4 and 5.
4 and 5. Yes, madam, for Revenue Department. Yes, any objections?
My lord, we have not received a copy of the substitution.
When did you enter appearance? After filing or when? Mr. Islam, why didn't you serve a copy?
My lord, to clerk has already submitted.
You have not given copy. Give him a copy at least for the fairness. Otherwise, we'll
My lord.
allow this. No,
My
no, no
my-
issue. But let it be done in a transparent manner. Give him a copy. We'll have it on Wednesday.
My-
Okay. Heard Sri B. Islam Learned Council for the applicants by which they have sought substitution in WPC, in the connected WPC 4933 of slash 2023. Para. Your name?
TL Chaudhary. TL Chaudhary.
TR.
TL.
TI.
LL.
TL. 3 TL Chaudhary, Learned Counsel for the respond number
4 and 5.
4 and 5. Respondent numbers 4 and 5. However, informs this court that he has not been served with a copy of the IE. Full stop para. 3. Islam, the Learned Counsel for the petition applicants undertakes to serve a copy to Sri Chaudhary during the course of the day. Para. Please for consideration on 24/4.
ठीक है
Regarding that nomination, the Lordship has kindly ordered it at 18/12/23. That is very clear. Whether he has been nominated or not. As per the rules, one of the secretary is to be nominated by the SP. 18/12/20.
Just a minute, please. Which order? No, as
Your Lordship.
can you just
order-
brass the
My lord,
just
this, I filed application
briefly
for
state the facts.
review of the order at page 83, madam.
83.
Yes.
In your review petition.
Yes.
It was something to do with VDP, secretary.
Yes.
83. Yes, if you read this order, perhaps everything will be clear. The order which you are seeking review.
Yes, my lord, the present page from page 80, my lord, may I read, madam?
Just a minute, please. 80. (12:10) was the judgment.
Yes. Para 9 is the judgment, fact, your lordship will get it from page 2,
Paragraph
paragraph 2,
of page
page
80.
80.
Okay, please read.
I'll read, madam. The present challenge made in this writ petition is with regard to filling up the post of secretary of the Durgabari Village Defense Party in the district of Bongao. It is the case of the petitioner that he was the-
You were the respondent number 5 in this.
Yes,
okay.
I did not appear because copy was served and but it was not from the court, therefore he did not accept.
Okay, doesn't matter.
This is the case of the petitioner that he was earlier the secretary of the for the tenure 2016 to 2022. After completion of the term of the VDP, it is 5 years, the said VDP was required to be reconstituted. Petitioner and the respondent were side 5 were the contenders for the post of secretary. A general meeting was held on so and so in the presence of the concerned persons, including the in charge Vidyapur outpost and the OC of the Bongao police station. In the said meeting, it was resolved that though there were certain allegations against the petitioner, the same were found to be false, and the meeting had ultimately left the decision to be taken by the OC and in charge IC of the concerned police stations and outposts. The said 2 officers, after deliberations and considering the credibility of the 2 candidates, had selected the petitioner as the secretary of the said VDP, and accordingly the VDP was constituted with the petitioner as the secretary. So that this is in violation of the rule. The grievance of the petitioner is, however, with regard to communication details so issued by the superintendent of police, Bongao of the constitutions of various VDPs under the Bongao police stations, and so far as the Durgabari PDS is concerned, the respondent number 5 has been shown to be the secretary. That your lordship will come and see at page 54, madam. 54. This is
50,
the constitution.
54.
Durgabari VDP, as your lordship got.
Yes.
Durgabari VDP President Azizur Haq, Secretary PR Ali Sarkar. This is the review petition. Ballot signature is Superintendent of Police, Bangag. So again, going back to the judgment, Malad, page 81, Sri Mahmood, the learned counsel for the petitioner has submitted. There are no reasons for ignoring the claim of the petitioner, also to take a contrary stand after the general meeting has selected the petitioner for the said post. It is further submitted that in the said meeting, the officials of the concerned Thana were there who had taken into account the credentials of the two candidates and came to a finality to select the petitioner, and that decision was not the matter of any challenge. He accordingly submits that the impugned communication so far as it relates to Durgabari VDP is liable to be set aside and a direction be issued to the state committee constituted with the petitioner as the secretary. The learned counsel has also submitted that the records would show that the majority of the people are in support of the petitioner, and for some extraneous consideration, political influence, the respondent number 5 has been thought to be favored. So ultimately, my lord, your lordship has held court to pay paragraph 9, paragraph 8 and 9, my lord. The impugned order dated 7/4/22 by which the respondent number 5 has been made the secretary of the VDP does not contain any reason. This court has also seen that the order is contrary to the resolutions taken in the general meeting dated so and so, whereby the petitioner was found to be more suitable, and in fact, the VTP was constituted with the petitioner as the secretary. This court has also noticed that the respondent number 2 in his first affidavit dated so and so, more particularly in paragraph 5 thereof, has stated that the service of the petitioner as the VDP in the earlier
Okay,
tenure
okay,
was
we have more or less
now
understood.
that the rule. your lordship-
The main,
Yes, your rule
content-
was not produced before your lordship.
no, the basis of this order is a general meeting of 27/2/2022, wherein the writ petitioner was preferred over you.
Yes,
Allegations against the writ petitioner were found to be incorrect, and that meeting was also
Right.
attended by certain officials of the police department.
now
So
18
we thought that we decided that the impugned order 7/4/2022 is not in consonance with our resolution of the general
Yeah,
meeting.
because
Your contention is that it is guided by a statute.
yes, the organization rules is there, my lord.
Please.
Assam Village Defense Organization Rules 1986, page 85.
85,
Yes.
yes, please.
Assam Village Defense Organization Rules 1986, Chapter 1, General. Rule 5, your lordship will kindly see page 86. I'm sorry,
Page 86 Assam, or let us write the Assam. Okay.
Village Defense Organization Rules 1986, Chapter 1, General.
Okay. Village Defense Organization Act. It's an act.
My lord,
It's an act,
yes, my lord.
1966. An order by the governor. Okay.
The government notification
Yes. Notification is dated
my lord, 7/11/86.
7/11/86. Notification. Okay.
Yes. It is under section 18 of the Assam Village Defense Organization Act 1966.
Okay.
Now rule 5, your lordship can say 86.
Rule 5 at page 86.
Yes. The VD primary committee shall be formed by the district village defense officer on the recommendations of the Thana and sub-divisional VD officers with one adult member from each family of the village or a group of village. The minimum number of family of a village or a group of village to constitute a primary committee shall be 100, and jurisdictions of such primary committee will be coterminous with the conventional boundary of the village or group of villages, as the case may be. The member of the primary committee shall select the president by majority opinion and the secretary of the committee will be nominated by the district village defense officer from amongst the primary committee member. The Thana officer of his representative shall be the convener, organization of the committee, who shall not less than be sub-inspector in rank. So this secretary of the committee will be nominated by the district village defense officer. He is the my lord superintendent of police. Your lordship will kindly see sub-rule 2. Sub-rule 2, my lord, that definition of district village defense officer is there. Page 85. Means the superintendent of police of the district concerned. As your lordship got it. So according to me, my lord, the present respondent number review petitioner has been nominated. Your lordship will get it more from the record, as is reflected from page 84.
Hmm.
Question of election or election doesn't.
Unlike the president's post.
Mild. Because this was not brought to your lordship's notice by anybody. I'm surprised, my lord, even the superintendent affidavit filed by the superintendent also does not speak about
No, nothing, there is nothing.
nothing.
Yes.
So therefore, my humble submission that the lordship will review and
So you are trying to contend that the irrespective of whatever decisions have been taken in the general meeting, that
Yeah.
will have no consequence or bearing in the nomination by the
superintendent.
village defense, what is the village for district village defense
District village
officer, which is the SP.
Yes,
It is the prerogative of the SP to nominate anyone as the secretary.
secretary.
And that has been done by the SP.
That
So
has been done by the.
his contention of his selection in
Yes.
the general
It's not
meeting,
likely
general
to be
body will
interfered.
not have any bearing. Okay, yes, understood, yes. We'll also seek your clarification, Mr. Dhar. Since he is the petitioner and this order, if it's reversed, will affect him. So we'll have to hear Mr. Mahmood. Okay.
First thing, my lord, this review petition is not maintained.
Okay.
Because earlier, the whole case was heard in detail.
Okay.
Your lordship passed the order on bearing. Maybe wrong or right, that is another matter. But a long and detailed reasoning order was passed.
Wow.
So this review petition is not maintainable. Second thing is this, my lord, he received notice, but did not appear.
Okay.
But here, categorical, he put his signature on the first letter he wrote. And this is in the Justice Service Deputy.
Okay.
First letter he wanted to write PRP, only P that was given.
No, let us assume that he has received and not
So
contested. He has not
there are
contested.
so many witnesses, they have put their signature.
No, we have accepted this. He has
And
received.
their mobile number is also there. So he has not come with clean hands.
Hmm. Yes.
The other point, lordship would say, the review petition by learned friend has shown
Hmm.
that the matter should be approved by the SP. The public will select the president.
Hmm.
and SP will nominate the secretary.
Hmm.
SP would nominate the secretary.
Hmm.
Now, Lordship would kindly say it was not recommended by SP, it was not approved by SP. For instance, Lordship would kindly say it was recommended by CO video.
Which
Uh,
page?
CO video.
Page.
Page, my lord, to kindly say, page 50 of SP's affidavit.
Part of the
SP's affidavit
part,
dated,
part of the review petition.
yes. It was filed on 28 to
Is
23.
it part of the review petition?
No, it is not part of the review petition, but it is part of writ petition.
Okay, SP's affidavit. We
Yes,
have
SP affidavit dated 28 to 23, kindly see page 50.
internal page.
Internal page is marked like this, 50.
No.
In meeting dated 27 to 22.
Paragraph.
Paragraph, there is no paragraph number, but it may be seen at the first page, it starts.
Okay, we'll take the writ petition. Just a minute, please. Page 50, you had said.
Yes, page 50, Annexure A of the affidavit filed by SP. This is his second affidavit. He filed two affidavits. First one is the second one.
Second affidavit.
Annexure A, it is the proceeding of the meeting dated 27 to 22.
Page 50. Okay. Type copy, the meeting.
Meeting 27 to 22. Yes, Lordship would say 50 bottom after 4 lines. Also, the allegations against the former secretary of Durgamari Village Defense Party has been proved as false.
Yes.
In fact, the former president of Durgamari VDP, Mohammad Jabatullah Sarkar, has alleged that his signature was falsely taken under pretense of formation of a new village defense party. So, my lord, these are the handiwork of, though there is no proof his signature was taken, but who is the ultimate beneficiary? Review petitioner is the ultimate beneficiary if the review petition is allowed. So, the finger points to him. Now, kindly come to page 51, bottom. For the post of president of the new VDP, one name has been recommended by the people present in the meeting. However, for the post of secretary, 2 names, namely Naushad Ali and Pyar Ali Sarkar, have been recommended.
You're Naushad.
Yes. This is very important matter.
Naushad is the writ petitioner.
Writ petition. Now, here Lordship would say, however, the post of
Pyar Ali is the respondent number.
respondent number 5 in the writ petition.
Okay.
In the writ petition.
Okay.
So here Lordship would say, however, the post of secretary, 2 names, namely Muhammad Naushad Ali and Pyar Ali Sarkar, have been recommended. It is recommended by people. By people, not by SP. So if the argument of violated friend is accepted, it is not as per law, as per the guidelines, because it was recommended Secretary of 2, namely Mohammed Shahid, recommended by the people present in the meeting. The people present in the meeting, being unable to finally decided between the two, has requested the concerned officer
Hmm.
in charge of Bidapur outpost Sri Tapos Fagish Dole
Hmm.
to make the final selection between the two candidates, and also has stated to have no objection to the final selection made by him. It was also undertaken in the meeting that the decision of the OC-IC of police station will be accepted by people present in the meeting. As such, for the purpose of OC-IC, after deliberation as per the credibility between Pierre Ali and Norshad Ali, Mohammad Norshad Ali was selected as being more competent for the post of secretary. So, Lordship would say, Norshad Ali was selected by the committee. Selected by the committee, recommended by the committee, and OC Bongaigaon police station and in charge Bidapur outpost. So it is, there is nothing about SP. SP has done nothing. But this recommendation was ultimately changed because of the interference of the local MLA. That is, that is our clear case. So this, as per this recommendation, I should have been appointed, but I was not given. Now appointment was given by SP in favor of fair election. So on the basis of that, if what my learned friend has said, it is the job of the SP, but it has not been done by SP. It is done by public, and that is also duly signed by, then Lordship kindly come to page 53. This is the handwriting, xerox copy. Yours faithfully, Karuneshwar Sarkar, CO video,
Fifth page.
page 53 of the state affidavit.
53.
Xerox copy. It is signed by CO VDO, Circle Organizing Village Defense Officer, not by SP.
Yes,
That's why I said the signature.
yes, yes.
So this is not SP. So that was done by CO VDO, not by Village Defense Officer. That is the SP. It is not done by SP. Now, let us see the order of the appointment of this person, that for that Lordship may come to page 29 of the writ petition.
Just a minute, please. Somebody.
Page 29 of the
This, this communication at page 53, which you are just referring, by signed by the CO video,
yes.
this also has Durgamari VDP.
Yes.
And here you are Pierre Ali Sarkar. What is your name?
I am Norshad Ali. My learned friend is Pierre Ali.
Okay, okay. The Durgamari is at is the first, serial number first, at page 53. Please come to 53, the handwritten copy.
Yes.
I have the honor to inform you that the following executive committee of so-and-so reorganized dissolving the old committee under so-and-so. This is your release R5. R5. Are you trying to contend that this communication 33/2022 is not in accordance with the resolution of the general meeting?
The general meeting
General meeting has chosen you.
and also against the law which my learned friend has shown before our lordship. Kindly see now the law. Law which my learned friend statute, that statute, let us go to that statute first. Then it will be 87 of the review petition, page 87.
Yes.
President of the primary committee, the president of the primary committee, page 87, lordship has seen.
Yes.
Shall be responsible, the ticketing secretary, as the
Yes.
matter is secretary, so kindly secretary.
Hmm.
Secretary of the primary committee, the secretary of the primary committee shall record the proceeding of the committee, meetings, etc. And regarding his appointment, it is page 86. Here, my lord, one thing I am appraising your lordship, my lord.
Hmm.
This Pierali Sarkar has no spelling. He only can put his signature. So many things have to be done. I don't know how the MLA recommended his name. MLA has no role here. He only knows that is a clear case that he is totally illiterate, and they have not denied this. They are saying that there is no qualification necessary. Even then, how he can maintain the proceeding? That is also very important matter. Now, kindly see now, page 86. He has no school education at all. How he
Page
can,
86. Where is
Yes.
your statement?
page 86, kindly
Ah,
see now.
Yes.
86 top.
Hmm.
The VDB
No,
primary
that we have seen. Where is the statement regarding that he doesn't have any qualification?
yes.
Number one, immediately we'll ask you, where is the requirement of educational qualification?
No, there is no requirement.
But you have contended seeing the nature of the duties
Yes,
which will have to be performed by a
Yes, yes.
secretary, minimum education qualification would be
Yes, sir,
necessary.
yes.
That is your comment. We have understood.
he
that.
does not know, madam.
Okay.
And this is he simply says qualification is not mentioned. Or
But he is not denying.
They are not denying.
Okay.
He has nothing. He has
Where
not-
is your statement that he doesn't have any qualification?
Yes. That is in this picture.
Okay.
My lord, may kindly see page 8, page 8 of my writ petition, para 5.
Yes, please.
After 3-4 lines, lordship would see. But unfortunately, he was not appointed due to a communication letter dated 8/2/22 forwarded by the local MLA 32 number Bongaigaon LSC to the officer in charge of Bongaigaon Police Station. And instead of the petitioner, a new inexperienced candidate, namely Pierre Ali, was appointed as the secretary of Durgamari VDP by the appointment letter dated 7/4/22, which has caused serious prejudice, injustice, and detriment to
We
the
have
petitioner.
read this. Where is the statement regarding qualification?
Yes, I have. Moreover, the petitioners endeavors have even on our villages, they have expressed their not being
Not
appointed
there.
secretary.
It's not there.
It's just,
Not there.
it is there, madam. It's there. Let me. My lord, I am showing you letter.
Yes, yes.
For the moment, Lordship, kindly
Yes, yes,
come to
please.
page 86.
86
Yes,
of the writ petition.
of the review bit.
Yes, we are in 86.
Here. Here, Lordship would say, the VDP primary committee shall be formed by the district village defense officer on the recommendation of the Thana and sub-divisional VDP officer with one adult member from each family of the village or a group of village. The minimum number of family of a village or a group villages to constitute primary committee shall be 100, and jurisdiction of such primary committee will be coterminous with the conventional boundary of the village of or group of villages as the case may be. The members of the primary committee shall select the president by majority opinion, and the secretary of the committee will be nominated by the district village defense officer. Here, this is the way. He will be nominated by village defense officer, that is the SP. Now, Lordship has seen he was recommended by village level committee and by majority of votes, and lastly, due to differences in opinion, the matter was entrusted with OC and IC, and they recommended his name. They recommended the name of Pierre Ali Sarkar. Sorry, Naushad Ali.
Naushad.
Now, let us go from other side. Pierre Ali Sarkar was not recommended. Suppose he has been recommended. That recommendation is not the SP. It is the recommendation of the primary committee and OC, IC. So they have no role at all. If the rule is followed, my lord, am I clear, my lord? If the rule is followed, they have no role up to the extent of selecting the president. Letter and so, yeah. Okay.
Yes.
Now, Lordship would say, what is the things coming that after selection or election of the president of the VDP, there is no role at all. There should be full stop. Then matter would go to SP. SP will recommend one name. But here, everything is done by village level primary committee, OC, IC, and COVDO, not village defense PDO. The village defense organizer, that is SP, he is not here. Here is committee, here is OC, IC, and COVDO. So even then, that appointment in favor of Pierre Ali, which we have challenged and which was ultimately Lordship has set aside, that order is otherwise also illegal. SP did not recommend his name. It was recommended by other person. So my learned friend has no case at all on merit. Well, here, now, my lord, I have regarding his experience, it is, my lord, in page 50, page 50
Of
of affidavit and reply,
In
That
the,
is,
in the writ petition.
no, it was an affidavit in reply was
That is in
filed
the
against the affidavit of SP
In the writ proceedings.
in a writ proceeding, yes.
Page 50.
Page 50.
Yes.
The petitioner has also the support of 208 villagers, and that thereafter Lordship would say after his satisfactory services have been acknowledged by the SP in Panorama Science to Court. Yes, please to court. Page 8 of the writ petition. Page 8 of the writ petition. He is inexperienced. Page
Yes.
8
Yes.
of the writ petition.
Yes. That we have seen.
Here, police station instead of petition a new inexperienced candidate, but here they have replied. They have replied in the review petition that formal education is not necessary. So otherwise they have admitted. They have not annexed any qualification certificate, and duties are very, very dangerous matter. So many anti-social persons are coming, so many extremists are going on. These are to be reported. It is very important. Every time they have to report that some unknown persons have come.
No, in absence of pleadings, we may not
Yes.
go into the respect. We should have a pleading. Other points, okay, we are considering.
No, no.
Anything else?
Let me say my submission, my ruling.
Okay.
No, I have already submitted the citations.
Yes, please.
I've already given citation.
What is? So,
2004,
did you my silo open subcommittee? No. 2004.
2004, 13 SCC, 377, para 7.
Okay. Paragraph 7. Yes.
In our view, the review could not have been allowed on the ground that some other court had taken a different view. Merely because two views are possible is no ground to review a judgment already passed. Even otherwise, the judgment of so and so has been set aside by this court on remand on 14/12/99. A review petition which was filed against the judgment as so and so has been dismissed by us today. So here, Lordship, there may be two different views, possible two different views, but that is not a ground of review. Actually, in other words, this review is appeal in disguise. Then Lordship would say,
Yes.
2013, 8 SCC, 320, para 11 and 20. 12, no, 20.
Paragraph?
Paragraph 12, 11, first kindly say
11 and 12.
11, 12 onwards. So 14, 15, 17, 18, 19, up to 20. Here, para 11, first kindly see. Further part 8, order 40 of the Supreme Court rules 66 deals with the review and consists of 4 rules. Rule 1 is important for our purpose. The court may review its judgment on
That is the Supreme Court rules. No, 11 will not be relevant. So read the principles laid down.
principle laid down mirror, that may be seen
Yes.
para 10. Order 47 Rule 1 of Code of Civil Procedure provides for an application for review which reads that application for review any person considering himself aggrieved by a decree or order from which an appeal is allowed but from which no appeal has been preferred. By a decree or an order
You're reading paragraph
10.
10.
Yes.
10 is the quotation of the.
Yes,
47.
47.
You can avoid this.
47, yeah,
Avoid this part.
47. Yes.
Read the relevant part, please.
Now kindly see page 14, para 14,
1-4.
1-4.
Yes.
Review of the earlier order cannot be done unless the court is satisfied that material error manifest on the face of the order undermines its soundness or results in miscarriage of justice. This court in so-and-so has held as under. A review is not a routine procedure. Here we resolve to hear the Kapil at length to remove any feeling that the party has been heard without being heard. But we cannot, without being heard. So it is our case. It is also the present case. He may say that I was not heard, but actually he did not come. But we cannot review our earlier order unless satisfied that material error manifest on face of the order undermines its soundness or results in miscarriage in justice. So Lordship would say here, now para 15, an error which is not self-evident and has to be detected by a process of reasoning. Here, that is very important. In review, there cannot be a process of reasoning. Long argument is not necessary. To be said to be an error apparent on the face of the record, justifying the court to exercise power of review, a review is by no means an appeal in disguise whereby an erroneous decision is reheard and corrected but lies only for patent error. Here, it is settled that review proceedings have to be strictly confined to the ambit and scope of Order 47, Rule 1 CPC. So this is there, my lord.
Yes.
So, lastly, my lord, the Supreme Court said, that is page 19 and 20. 19. Review proceedings are not by way of an appeal and have to be strictly confined to the scope and ambit of Order 47, Rule 1 CPC. In review jurisdiction, mere disagreement with the view of the judgment cannot be the ground for invoking the same. As long as point is already dealt with and answered, the parties are not entitled to challenge the impugned judgment in the guise that an alternative view is possible under the review jurisdiction. Summary of the principle. Thus, in view of the above, the following grounds of review are maintainable as stipulated by the state. When the review will be maintainable, discovery of new and important matter or evidence. So, Lordship, it is already the reproduction of Order 47.
Yes.
Or Section 114 of the CPC.
CPC, right.
So, my lord, even if a second view is possible, review would not lie. It is a full-head judgment. On perusal of the record. On perusal of the record. Now, so this is not, this review petition, first I have said it is not maintainable. Now, 1997, 8, STC 717, review. That Lordship may kindly see para 9 and 10. Para 9.
Para 9.
9 and 10.
Yes.
Under Order 47, Rule 1 CPC, judgment may be open to review inter alia if there is a mistake or an error apparent on the face of the record. An error which is not self-evident and has to be detected by a process of reasoning. The same thing, man.
This was already taken care in Kamlesh Verma case.
Can hardly, yes.
This
Can hardly be said to be an error. It is not error. It cannot be hardly to be said an error apparent on the face of the record justifying the court to exercise its power of review under Order 47, Rule 1 of the in exercise of the jurisdiction under Order 47, Rule 1 of the it is not permissible for an erroneous decision to be reheard and corrected. A review petition, it must be remembered that it has a limited purpose and cannot be allowed to be an appeal in disguise.
Yes.
So similarly, my Lord, para 10 is also saying like this.
Yes, yes.
My next judgment 2008, 8 SCC 9 para 26. And 28, 26.
2008.
2008, 8 SCC 92 para 26 and 28. Now reading 26. It is true that once an authority exercising quasi-judicial power takes the final decision, it cannot review its decision unless the relevant statute or rules permit such review. But the question is at what stage an authority becomes functus officio in regard to an order made by him. So-and-so case gives the following illustrative definition of the term functus officio. Thus a judge, when he has decided a question brought before him, is functus officio and cannot review his own decision. So now, my Lord, in view of this ratio laid down by the Honorable Apex Court,
Now, how is 26 relevant?
Lord,
How is the observation made in paragraph
yes,
20?
your Lordship, as in my opinion, Lordship has become functus officio.
No, no.
Because
Here it only refers to quasi-judicial bodies.
Yes.
Where the relevant statute does not permit review.
no, does not permit, that is one aspect of the case.
It says that if the statute does not give any power for review, then you cannot exercise such powers. It has to be conferred by a statute. This
Well-
perhaps will not be helpful to you.
No,
If you are
latter-
contending that a writ court does not have the power for review,
latter
then
part,
no,
latter part.
the question of functus officio will come only when the statute does not confer any review powers.
Yes.
Here, there is no dispute in the bar that a writ court can function. Obviously, that's it.
Institute, that is 47 has two aspects. One aspect, it can be exercised. Another aspect, it cannot exercise in what condition?
Those are the different matters. One is conferring of jurisdiction, one is how you exercise your jurisdiction. If it is not conferred, then whatever you cannot exercise. But if it is conferred, you may still argue that conferring the jurisdiction will not mean that you can review all judgments. It cannot be disguise, appeal in disguise, number
Yes.
one. You cannot go into the reasonings. If there is another view possible, that also should not be
Yes,
altered.
yes.
You have understood, but this will not help you. This
Para 28 can listen now. Para 28, middle portion.
28.
Thus,
Okay.
after 10, 12 lines,
Yes.
thus, Rashmi said,
Mm.
thus, where a judgment is reserved, mere dictation does not amount to pronouncement, but where the judgment is dictated in open court, that itself amounts to pronouncement. But even after such pronouncement by open court dictation, the judge can make corrections before signing and dating the judgment. Therefore, the judge becomes functus officio when he pronounces, signs, and dates and judgment subject to section 152
Mm.
and power of review subjective. So it was announced in open court,
Mm.
dictated in open court. Your Lordship has signed it. It is
Mm.
dated also. So this is very much, I think, applicable in the present case. And our High Court, one recent judgment of our High Court is this, my lord, that I have here, one case review petition was there,
Iqbal Hussain.
Iqbal.
Yes, we have it. We have.
Now, Lordship would kindly see para A. In order to exercise the power of order under 47, order 47 of the species, there must be an error apparent on the face of the record. The error contemplated under this provision of law must be such which is apparent on the face of the record and not an error which is to be fished out and charged. It must be an error or error of inadvertence. The impugned judgment, there are no errors apparent on the face of the record. The view expressed by this court is based on the merits of the case. I find that there are no such errors as has been pointed out by the learned counsel for the petitioners taking review. I find that the review petition is devoid of merit and stand dismissed accordingly.
Okay.
So, my lord, this is normally a decision of the coordinate bench to be followed,
Yes, yes.
or matter may be referred to larger bench. That lordship is aware about that. Now, my submission, my concluding submission is this,
Yes.
that even the order, the earlier order, which was passed by SP, that appointing P.R. Ali Sarkar as the secretary,
Yes.
that order is also illegal. Otherwise illegal, because this is not recommended by him, it is recommended by committee. So otherwise also that if even if someone brings the matter to the notice of the court will pass appropriate order. Even if suo motu, this type of order can be settled, because it is not in accordance with the statute which my learned friend has taken the center. Now, so far this regarding qualification, my lord, their review petition, kindly see para 2 of their review petition. That qualification. They have said, para 2, space 7, that the review petition respectfully says that in the writ petition, the opposite party, respondent number 2, has filed an affidavit in opposition stating entirely that there is no criteria for minimum qualification for the post of president and secretary of village defense party, except the post of CO, PDO. So that is not our case. Here, they want to say that that is not necessary. And there is no criteria for minimum qualification. So that means they have no qualification. Had they any qualification, they could have annexed it. They only said there is no criteria fixed by the rules that a person should be minimum qualified. But if your lordship only goes in the interest of justice and in the interest of the society, he has to maintain the record, he has to maintain the proceeding, he has to report the matter. It is on record manner I am submitting. He has to maintain who is coming to village, unknown faces are there or not, immediately whether they are involved in which organization, maybe extremist. So many things have to be done. It is quite impossible to discharge such function by this review petitioner because he has no schooling at all.
This is a factual assertion. You should have said.
He shall have to, my lord.
You should have said that he doesn't have any
I'm
education.
saying, well, because it
You have
takes-
not said where he gets a chance to rebut.
He has to.
He has in paragraph 2, he's only quoted what was the stand of the respondent number 2 in the affidavit. That is not his statement.
No, if.
You are correct in contending that since
because
he is
he-
emphasizing.
my lord, I am submitting. He has to take help of another person.
Okay,
Then what will be, my lord? Secrecy will go to another person.
you are correct. Okay, Mr. Dhar.
So, in this way, this review petition does not have neither merit nor maintainable. And he has not come with clean hands because he refused the notice and then says, I have not received it. But his first letter is there. First letter P. P is in our opinion. Then
P means Piara.
P wrote and then a telephone came and he did not. It is not true.
You are narrating as if you had seen the event. He was signing, then telephone came and he
Yes.
stopped.
Yes. Hello.
Okay. We'll consider definitely. Yes, Mr. Dhar, controversy has arisen.
My lord, I will
And
try to be more.
you
than
did not assist the court at the first instance. You should have assisted. You have not brought the status to the notice. Mr. Mahmood could have answered at that time.
My lord. My lord, we file a affidavit, maybe, my lord, you are.
Okay.
That. My lord, now I'm just placing the two documents, my lord, only,
Yes.
your lordship. I will just initially go to the record. I will take my lord to the record. It's a small. My lord, this is a note sheet, my lord, the internal.
Yes.
My lord will find on top in the left hand side, it is SP Bongaigaon, that in the note sheet.
Yes.
So, my lord, this is, may I read, my lord?
Hmm.
Povodo,
See your video.
CEO video, Sarkar has submitted a prayer along with the proceedings of meeting through the officer in charge, Bongaigaon. PS for dissolving the old committee of Durgamani video VDP and create for approval of the new committee, my lord.
Hmm.
Put up for favor of your kind perusal and approval.
Okay.
So, my lord, this is first thing. Then the three names, the name of PR Ali is in second for secretary. It's there. Then comes my lord. Peruse the minutes of minutes submitted and forwarded by the CEO video Sri Sarkar for dissolving such and such, my lord.
Hmm.
So this goes down, my lord, recommendations, everything. The next page, my lord. In bottom, my lord will find put up to SP sir for favor of your kind perusal and appointment. If deemed fit, the committee were formed as per guideline. So signed in bottom, my lord, by Deputy SP. So the Deputy Superintendent Police, my lord, he puts up this for SP, my lord. Then, my lord, there is a signature of SP, signed, approved. The next page, again, it continues, my lord. There are some other, the next page. It continues, my lord, for other.
Mr. Dhar, you have been in in this post. You don't know how to read a record. I'm very sorry. You don't even know the chronology how to read the record. You take the original, perhaps maybe because of photocopy, you have not understood it.
Yes, my lord, it has gone from.
No, not like that. It's not so easy. You need to apply your mind. You deal records on a day-to-day basis. We don't deal.
Bro, this was not brought.
No. Records is okay. Mr. Dhar. Maybe some inadvertence on your, okay, left page, okay.
Yes,
Have you seen down below? Down below of the left page.
Yes, my lord, this page, my lord.
Is there an arrow? Down
Yes,
below on the
yes,
left
ma'am, there is
corner.
arrow, there is
Arrow
arrow.
means it's writing by whom? It's the SP. You have to turn the page. This is the second page.
That is approved, my lord.
Yes, not down below. Who's signed? After just turn over the page. It is not a continuation. Is on this side. Yes, this is the
side, yes, my lord.
continuation. This is the second page.
In the instant case, I am of the opinion that
Yes,
there should be.
you have missed the chronology.
Yes, my lord.
He is writing, continuing to write.
continuing,
That
my
is the
lord.
second page.
Yes.
And he already approved the name of Mr. Das, clients.
Client, my lord.
And that is the
there.
writing of the SP.
My lord.
And initially, that was the first page. That first recommendation of one president and two secretaries. No, you turn over the page.
Yes.
And this page here, right side page, top. See the three names are there. No, the same. Turn over the page. Yes. On the right page, right side. Yes, just
Yes.
two names of secretaries there.
Yes.
Sent to the SP.
Yes.
SP gives the recommendation. See the reasonings that he has completed 5 years. And next page. He has completed 5 years. A new secretary should be given an opportunity.
Yes.
You should read out this. These are relevant or consideration which we may examine whether those are relevant or not. This page ends with the previous pages. While you put in the pages, this is the order.
I got it, my lord. The dates I make, then my photocopy, it was opposite.
That is right, probably. No, doesn't matter. No, you have to indicate there is an arrow. Yes, where you are holding that page.
Yes, my lord. There is an
Arrow means this
It
page.
came back. Yes, my lord.
While putting in the pages, it
The
should.
note sheet.
Yes. It doesn't matter.
So, my lord,
And see the reasonings, whether he has signed any reasons. Please read the note
Yes.
for Mr.
having
Mahmood.
considered the petition submitted to OC Bongaigaon and forwarded by MLA Bongaigaon to the undersigned, I have directed to conduct a fresh meeting and find out the veracity of the complaint petition.
Hmm.
Accordingly, it was found that the present secretary Nausad Ali has been assigned as secretary Durgamani VTB for 23/5/2016.
Hmm.
He has completed 5 years.
Yes.
That is his tenure is over.
Okay, then read.
In the same post, as per the Assam Village Defense Organization Rules 1986, Rule 5A, under Chapter 2, it is mandated that the secretary of the VTP will be nominated by the district village defense officer, that is SP,
Hmm.
and only the post of the president is selected by the majority of the VTP.
Correct.
In the instant case, I am of the opinion that he has taken a
Opinion that,
opinion,
yes.
that there should be a change in the post of secretary. Since he has completed more than 5
5
years, and
years.
an opportunity could be given to a new
New
incumbent. Opinion taken, my lord. My lord, I'm sorry, my lord. It will. That's all.
Note sheet reflects that there was application of mine which is in consonance with the rules.
Yes, rules, and he has taken a decision.
He is the competent person.
Yes, if you go by the,
Rules.
no, notification, rules,
Rules. And he has referred the rules.
rules.
This should have been brought to the notice.
And two things, my lord, he has completed, the writ petitioner has
See,
completed. 5
that
years.
completion is not a impediment. He can still be considered. But it can be a matter which can be taken as a reason that to give to a new person or not. And without even giving a reason, the prerogative is of the SP. He has, it appears that he has applied his mind. But this important note should have been got to us. He has even referred to the statute. We decided on the premises that the nomination has to be done in terms of the resolution of a general meeting. Where president was nominated, done. Secretary was nominated, not done. He makes out a case, we pass an order. The note sheet should be paginated first to remove all confusion. Here, incidentally, it is written by a particular handwritten, so we could understand
Yeah.
the chronology. Otherwise, it is not very easy unless it is paginated. There are no pages.
No pages, that is there. Sometimes,
Please give those relevant photocopy, or you can
I have a photocopy, my lord.
you can leave the record.
I'm leaving the record.
Okay. Yes, anything else? I think your job is done. Okay.
My lord, it's a blue page, blue mark.
Okay. Mr.
Well, I have nothing more to submit.
No, Mr.
Uh,
Mahmood has relied upon a number of decisions.
2013 8 SCC, got me, madam.
13,
Submit 2013 8 SCC 320, which has been provided by your lord, to your lordship by Mr.
Yes.
Mahmood.
Kamlesh
That-
Verma.
Yes, that protects me, my lord. Well, if there is error of law or error of fact and miscarriage of justice, my lord, that calls for a review. And here, my lord, the petitioner,
But Mr. Mahmood is trying to contend that this is an appeal in disguise.
no, this,
Yes.
this is a my lord, your lordship
Who
was
has that?
misled.
Who had that?
Your lordship was misled by not placing the, my lord, proper law before your lordship. It was a misled and it was, the proper law was not placed before your lord. By neither the authority. Neither the petitioner nor the authority. And so therefore your lordship has come into conclusion. And that leads to a, my lord, miscarriage of justice. So when there is miscarriage of justice, error of law and error of facts are there. Even the error of facts is there that your lordship has taken into consideration, then it is based on the election. So therefore, my lord, your lordship has come into conclusion. So that has been misled, my lord, by the petition. And now he is trying to take advantage of it. When due correction has been made by way of showing the rules before this. So therefore, my lord, I pray, my lord, there is sufficient reasons for review of the earlier judgment and allow the petitioner taking into consideration the rules placed before.
Okay.
One
I am
clarification.
very sorry to say, my lord, the affidavit also did not disclose the requirement of the rule.
If you are sorry, then what about your conduct?
My lord,
What about your conduct?
my conduct is also bad.
It's also very
No,
bad.
the-
You should have come and showed that this is the rule.
We just placed the matter before the court. Before him, he said, no, I did not receive from the, as you said, madam, he's not a learned man. He did not receive anything from the court.
Don't say you are not a learned man. Mr. Mahmood will jump up. He's indicating that you are not qualified.
Not qualified, there is no prescription.
He's admitting he's not a learned man.
And
Like Mr.
Learn-
Mohammed.
my lord, my learned friend has.
Okay, we are closing this. We are closing this.
Has objection on not misleading. Kindly see the order of the Honorable Court dated 23/6/20.
No, misleading we may not accept.
how he
We
can
may not
submit that
accept.
to-
You may not be aware of the,
Because
but we can say that there was no
you
proper
can-
representation.
Law is mentioned, order dated 23/6/22. Here, my lord has clearly, my lord Justice Buzur Burwa was there. He has discussed every aspect of the village defense party, BDP section, subsection, everything has been discussed.
Which order?
23/6/22.
In this proceeding?
Yes, in the writ petition. That was pointed out by me.
Page, which order?
Order dated 23/6/22.
23/6.
My learned had not, perhaps due to, due to shortage of time, perhaps he did not go. But he should not say like this, because this is,
23/6.
I submitted, and on my submission, this was recorded.
23/6/22.
23/6/22.
Okay, where? Hmm.
In details, the law rules have been discussed.
You're absolutely correct. You have produced a copy of the act
Yes.
and the notification.
Everything was done by-
But
My learned friend has
No,
not.
At that time, when your lordship was passing the judgment, the assistant should have been come at that place.
no,
No.
at one point of time, it was shown. It doesn't matter. Okay.
Now, regarding my tenure, I have filed affidavit, that is 21/9/22. Kindly wrote down.
No, tenure part we are going to take care.
45 years, one person is working.
That we have already
It
noted.
is on record.
We have already noted. Okay.
45 years, there is no
Third-
part.
Sri B.D. Das, Learned Senior Counsel for the review applicant assisted by J. Lotha.
Yes.
J. Lotha. Also heard Sri M.E. Mahmood, Learned Counsel for the opposite party writ petitioner. Full stop. Sri R. Dhar, Learned State Counsel has appeared for the official respondents and has also produced the records in originals pursuant to earlier directions of this court. Full stop para. The hearing is concluded and judgment is reserved. Okay.
All right.
Like the,
Finally,
finally,
see, after long,
it is nice working on Saturdays, my son.
no, that was the only reason. We knew that Saturday would not be a very hectic day. And Mr. Dhar, it happens at times, maybe because of the photocopy, doesn't matter. But, no, doesn't matter. No, doesn't matter. At photocopy, then because of the change of the color of the pen, you can page number. It's okay.